They said renewing a green card was routine. Today, even the simplest applications are being rejected without warning. One miscalculated trip abroad can cost years of residency. What follows is a true case exposing the harsh reality of immigration in 2025. The legal framework for losing a green card. Under the Immigration and Nationality Act, a lawful permanent resident can lose their green card in only two ways. First, by voluntarily signing Form I-407, formally abandoning residency. Second, if an immigration judge issues an order of removal after due process. Beyond these two situations, a person remains a permanent resident. There is no legal authority for USCIS to declare abandonment unilaterally. Yet in practice, the agency often uses time abroad as evidence to justify denials. That contradiction is now creating chaos for thousands of immigrants across the United States. Why long absences create major problems? When a green card holder spends over 12 continuous months outside the country, two separate issues arise. First, there is a presumption of abandonment that border officers may raise upon reentry. Second, the break in residence affects eligibility for naturalization. Both carry lasting consequences. In the past, many who returned after long absences were admitted after brief questioning. They were not forced to sign abandonment forms, nor placed in court. But in 2025, stricter enforcement and shifting policies mean travelers are far more likely to face removal proceedings or pressure at ports of entry. A case that reveals the contradiction. One recent case highlights the problem. A man spent about 12 months outside the United States to deal with a family emergency. Upon returning, officers questioned him carefully but ultimately admitted him as a resident. They did not initiate abandonment paperwork or removal proceedings. For years, he lived a normal life, believing his status was secure. Later, he applied for naturalization through Form N-400. His application was denied, not because of misconduct, but because his absence had broken continuous residence. He had not spent enough time inside the country before applying for citizenship. Filing again, and running into new obstacles. By the time he became eligible again for naturalization, his green card had already expired. Assuming renewal would be routine, he filed Form I-90. To his surprise, USCIS denied the application, claiming his year-long absence meant he had abandoned residency altogether. This interpretation defies the law. He had never signed Form I-407, and no immigration judge had issued a removal order. Still, the agency treated his absence as abandonment. For decades, I-90 renewals were almost automatic. Now, even long-term residents with clean records are facing denials. How USCIS is creating inconsistencies. The paradox becomes even clearer when considering the next step. Despite denial of the I-90, the man is now eligible for naturalization, since enough time has passed since his trip abroad. Filing the N-400 again should result in approval and eventually full U.S. citizenship. Adding to the contradiction, once the N-400 is filed, the receipt notice extends the validity of the expired green card, typically for 24 months. USCIS, therefore, denies renewal on one hand while simultaneously validating the card through the naturalization process. Such conflicting practices reveal deep flaws in the system. What happens at the border after long trips? For others, the consequences of long absences are even more severe. When residents return after more than a year abroad, officers frequently pressure them to sign abandonment forms. Those who refuse are often placed in removal proceedings and issued a notice to appear in immigration court. Some are held temporarily at airports before release. In rare cases, where there are criminal records or flagged national security concerns, detention may be longer. Still, most are admitted while their cases move forward. This reinforces the fact that only an immigration judge, not USCIS, can terminate residency. Why renewal denials are especially troubling. The new approach to I-90 renewals raises significant concerns. Historically, even residents with complex or troubling records could still renew. The goal was to ensure valid documentation of status. Today, the agency is using renewal applications as a way to challenge residency without due process. This practice leaves green card holders in limbo. Instead of directing cases to court for proper adjudication, USCIS issues denials that confuse applicants about their legal standing. Many fear traveling, renewing, or even applying for citizenship, despite being fully entitled to those rights under the law. The human cost of unclear policies. Behind every denial is a family forced to live with uncertainty. Spouses fear loss of benefits. Children worry about whether a parent will be forced to leave. Applicants themselves struggle with expired cards that complicate employment, travel, and everyday life. The psychological toll is immense. People who have contributed to the country for years suddenly feel that everything could vanish because of a single misstep abroad. The law provides stability, but inconsistent enforcement undermines that promise and leaves communities anxious about their future. Where this leaves us in 2025. The current situation demonstrates the urgent need for reform. If USCIS believes someone abandoned permanent residence, the appropriate step would be to refer the case to immigration court. There, judges could weigh evidence, hear arguments, and reach decisions consistent with the law. Denials without hearings lack fairness. Until legal challenges force clarity, permanent residents must act with caution. Long trips abroad carry heavy risks. Filing naturalization applications prematurely can trigger denials. And I-90 renewals are no longer guaranteed. Careful planning and professional legal guidance are essential to avoid devastating consequences. Final thoughts. The contradictions in today's immigration system are stark. A resident can be denied renewal for alleged abandonment yet be granted citizenship months later. Such inconsistencies weaken confidence in the process and create unnecessary fear among immigrants who deserve clarity. For green card holders, knowledge is power. Understanding the risks, preparing ahead of time, and seeking trusted advice can make all the difference. The journey remains challenging, but with awareness and support, lawful permanent residents can still secure their futures in the United States. Let's make this a community. Leave your comments, and we'll continue learning together.